We are here live. Welcome to the probate workshop. This is a space where if you're in North Carolina, particularly if you're in Durham County, North Carolina, and you need support or you're interested in knowing what the probate process looks like, every Wednesday we're here and we're taking a look and we're walking you through the steps. I am not an attorney. I'm not a financial advisor. I don't pretend to play one on my YouTube channel or Facebook community, but I am dedicated and committed to being a specialist and expert in this field. And I love sharing what I learn so that it helps make your process smoother. So today we're going to go over what is probate and the steps in the probate process for Durham County, North Carolina. If you are watching this live, that is awesome. Would love for you to comment and ask any questions that you may have. This hopefully can be interactive. If you're listening to this, perhaps on Spotify or Apple Music or wherever you get your content, thank you. And again, please leave a comment, share or review. It helps Google and Bing and all those places help get this message out there so we can reach tons of folks and help them navigate the process smoothly and hopefully recognize ways that they can actually avoid the process for themselves and for their family in the future. All right, so let's go ahead and rock and roll. I will share my screen. Live video comments show up StreamYard. Click on comment to show screen. Oh, okay. Oh, live video comments show up. Oh, all right. Awesome. Oh, now that's where I can see my comments. Someone was asking about that. All right. Cool. Let's see. Present. And so we will start at the beginning because that's a good place as any to start, right? All right. So what is probate? Probate is the legal process for selling the affairs, the estate of a deceased party. When someone passes away in North Carolina, or pretty much really anywhere, there has to be a way for all that living that took place, all the assets that were acquired, all the personal property, real property, all the debt that was acquired has to be addressed if it's in that person's name. And so probate is the legal process for handling that. Now, there are cases, particularly in Durham County, North Carolina, or North Carolina, that don't necessarily have to go through the full probate process. And that's usually based on the amount of assets or how much the property, the estate is worth and left over. If it's under $30,000 as of, well, it depends on the day of the death of the decedent, then it is considered a small estate. And if there's a collection of personal property that needs to take place, and it's usually a simpler process than properties, estate that have over $30,000 in assets, and that asset, the amount is based on the gross amount. So if you have let's say there's a property that's worth $200,000, but there's a mortgage on it for $190,000. So really, it's only about, let's say, $10,000 in equity. Still, the $200,000 is the total amount that has to be accounted for, and that would require you to go through probate in North Carolina. So the personal representative, they're responsible for taking care of probate. They're responsible for opening it. This is basically what we're going to go over today: notifying creditors, taking inventory and accounting, settling all debts and taxes, distributing any inheritances left over, and finally closing the estate. Let's see. So let me actually I'll go over what happens in the bank. That's for a different account. Yep. So one of the ways that I learn and share experiences, I'm at the county court office every week, connecting with the deputy clerks, the assistant clerks, the assistants to the deputy clerks, and they're awesome people in there, and they help me help other folks. Well, they help you. They're the front line. They're the ones that you've scheduled interviews with, the ones that are going to walk you through the different steps. But their hands are a little tied because they're not allowed to give any legal advice. And even though I'm not giving legal advice, my hands aren't as tied as much as I can direct or share my opinion for you. If you walk into the office, you'll see my probate workshop card there, or you might even see me because I'm there all the time. But we definitely want to let you know that I want to let you know that this isn't just coming from searching something on Google. This is something that they were committed to and committed to continue to learn the process because things change, right? So So the first thing you're going to do is once you actually have if someone's passed away and you have the death certificate and you are planning to open probate, is go ahead and start making an assessment of all the assets and debts that the estate may have. If you need a form, check out estateproservice.com. I have forms that'll help you fill it out. There's some great tools out there. Tools sort of like QuickBooks, or I guess QuickBooks is the right way to use it, but QuickBooks for estates. So if you're like me, I'm not a numbers guy. And so having those tools really help keep things organized in one place. Now, you're going to go and you or whoever's going to apply for being personal representative. If there's a will left behind and it's a valid will, then you will take it to the probate office. Well, I would call up there to get an appointment first. Get an appointment. Now, know that an appointment is going to take you about 2 months out for Durham County. So if you call today, it's going to be 2 months away where you'll probably get in there. The cases are pretty, I don't want to say backed up, but it's just there's a lot of cases that folks have to go through, and it takes a while. Probate takes a while. So make sure in the meantime that you go ahead and have the death certificate and that you make the appointment. And when you go there, they'll make sure the death certificate is valid. And if there's a will, you will also show the valid will so that they can verify it and start the process. If there's a will, then the will may determine who the executor or executrix is. That's the person who's executing the last wishes of that person. If there's a will, that's if someone died, testate. They have a testimony, their last testimony, and someone's going to execute those wishes. There may also be in the will a waiver of the bond, because the person who's the personal representative, you have a fiduciary responsibility. You are responsible for making sure that the estate is handled appropriately, and you can be criminally and civil charged if there's found that you are neglecting your obligation. So there's often bonds associated with it, but quite often the will state waive the bond for that person in North Carolina. Now, if you're an administrator, that means that the person passed away and either the will was not valid or there was no will left behind. And now there's someone who's going to administrate the probate, not necessarily execute the last wishes, but administrate it based on North Carolina laws, intestate laws to be exact. So the main difference is if there's a will or if there's not a will. Next, now this is something I want to put a caveat here. When you say start sending notices and notifications, I would not necessarily start reaching out to folks, to banks, to folks, letting them know that that person has passed away. The reason for this is that you want to be able to go ahead and gather the contact information because you know that this is what the next step will be. But I should really update this and make sure I make a note of this to say that you prepare to get ready to send notices and notifications. And another reason for that is because during the process, you'll have to send a notice to creditors in a verified or a qualified publication. In Durham, North Carolina, two that we use often are the Carolinian and the Carolinian and I was going blank on the News and Observer, the largest one out here. But the Carolinian is one of the smaller ads. I like working with them because they're quick and they can speak to you efficiently. And I believe the next one is the News and Observer. Oh my gosh, I'll have to put it in the show notes, but you definitely need to notify. You'll need to you'll email them or call them, or email is probably the best way. Share the death certificate with them, and they'll be able to set up the notice to creditors, and this will allow them to run it. They'll run it for 4 days, not 4 days, I'm sorry, 4 consecutive weeks. And after the 4th week, you can stop running it. And then creditors have 90 days from that 4th week to reach out to you, to send messages, because they'll have the information in the notice creditors, and reach out to you so that you could know what debts are being claimed. And again, claimed doesn't mean that they are valid. They're claimed. And even if they are valid, doesn't necessarily mean that they will have to be paid in full. And I'll get to that in a second. That's one of the reasons why I wouldn't necessarily send notifications just yet. Don't send notifications to banks and other places until you have authorization to deal with the estate. And that's whether you have the letter of administration or the letter of testament if you're an executor or administrator. And so once you have those letters, then you can, begin reaching out, because this will give you opportunity to access banks and personal information, as opposed to being locked out and having to wait to your appointment anyway. So let's rock and roll there. You'll administer the estate, whether you're executing or administrating. You'll do that. So you'll have to start managing and attending to what the assets are and preparing the disposition of the assets. And some of these assets you may determine or may find out you'll have to liquidate so that you can pay off any debts that are in the estate. And again, paying off the debts, there is a specific priority of claims. Let's say, for instance, there's not enough money in the estate. You do not need to pull money out of your pocket. You can't squeeze water out of a rock if there's not money in the estate. You can use some of the estate's assets to pay off the debt. Maybe there's a car or a house that needs to be paid for and it's determined specifically in the will that you can do that. Or as administrator, you've made the judgment that you need to do that. And so one thing here is that not only do you need to check the priorities of order of who gets their money first, or who gets it in the proportion that they get it. And you can hit me up or go to estateproservice.com, or just Google what the priority listing is, and we'll get that information to you so that you can know. But also sit down and call each one of them and let them know, hey, or ask them, would you be willing to zero this out? Closed mouths don't get fed, folks. I was actually able to have a $248,000 lien removed from I'll call him a client, from someone I was working with. And oh my gosh, the relief. He was not expecting any funds from we're actually buying this property. But because of negotiating, asking, they were able to write it off. And many debtors they'll be able to write it off or reduce it. And those who can't, you're back in the same position. So it doesn't hurt to ask for a reduction or a complete write-off. You'll also need to file taxes for every year that the estate is open. Some estates take a long time because of all the moving parts, or because your life is so busy. So you have to file at the end of each year. The final taxes will be during the final staging, where everything is zeroed out. So any income that came in between time that goes in the name or to the estate has to be accounted for. So to make sure that you are accounting for that. Now once the debt's all paid off and the taxes and everything is paid off, then you can start distributing to your heirs. And make sure any heir that says they don't want anything to do with maybe the estate or anything like that, there is paperwork you can use. It's called, here goes a big GRE word, renunciation of beneficiary. You also need to make sure that you get a receipt of beneficiary so that you can add it to the file, so that everything zeroes out. At the end of the final accounting, there should be zero left in the estate, so that it is settled. And that's when you'll finish up. You'll have your final accounting stage. You'll have your meeting with the deputy clerk. They'll review everything. Everything will be zeroed out, and you'll be able to pay your fee and move along the way. Now, some things to think about. I just said pay your fee. Each stage pretty much has a fee that you have to pay. The opening probate is a fee. The filing for notice to creditors is a fee. The filing inventory is a fee. The final accounting is a fee, and they're all quite often a percentage of what how much the gross amount of the estate is. So you're going to multiply the gross amount by 0.004, and the minimum is $15. So the estates can be pretty expensive, especially if there's a lot of assets in there. So, folks, let me make sure. Well, I will say, just as a probate specialist, there's a few ways that I can help you out. I feel like there's a lot of ways we can help you out, but 4 quick ways is helping you navigate efficiently. Sometimes folks just need someone else to especially in times that can be challenging, to just affirm, or just a sounding board, or say, am I doing these next steps properly? Would love to help you in that way. Also, recommending estate planning attorneys. I stay in my lane, and there are some amazing estate attorneys out there, and we can help you find one that fits your particular need. Not everyone needs a huge team that's going to go and litigate and challenge. Some just need administration, and some may need that, or there's everything in between and on the outside. So we make sure that you connect you with our statewide, and particularly Durham local group of vetted state professionals if you need that support. And hopefully it will reduce the cost of the attorney. Depending on how the payment structure is, the more we can deal with the administrative lag that they probably don't want to deal with, the less time that you're spent in the attorney space and less money, hopefully, it will cost you. And of course, we provide solutions to inherited property, whether that's helping you get top dollar, helping you keep the property and turn it into a maybe something great for your family, or an investment property for yourself or your family, or perhaps you need a quick and convenient solution. We definitely can provide support for that. And it really depends on what your needs are. We don't try to force ourselves on you, but it really depends on what your situation is. There's just some reviews. I'm loving reviews. Go check out Estate Pro Service. If you've worked with it, I'd love to hear a review. To get a review, this is, again, way people take a look, social credit and social proof and all that good stuff. So that's what we work for. We work for the reviews to get more reviews, because the more value I bring, it comes back. That's just the law of the universe, right? So again, that heart, head, hands-on approach, that's the approach that we take, and we hope that it can help you in your process. So let me see if there's any questions. There might not be any over here at all. We're doing this, I'm pretty much live every day. Well, I know I'm live every day. However, this workshop is every Wednesday, 12 o'clock. And throughout the week, I'm responding to different questions. And so check out the Life and Transitions Experts podcast. There may be a topic here that is specific to probate that can help you. All right. Until then, or until next time, let your light shine.